Thanks for welcoming me to present today to you all, and Rachel for reaching out to our office. I know Public Council Later, we go a ways back. We've had various folks come and migrate. Christy, obviously. Christy Lutz has just joined LATO, so I've had prior experience with LATO by working with Lauren Coddles for quite some time developing policy work several years ago. So I'm very appreciative to be here and to be speaking to you all. So this is my contact information. I neglected to put my extension on. It's 249. You're all welcome to contact me directly on my direct line at 249. I've been at Public Council for 12 years, going on 12 years now. And prior to Public Council, I worked at what is now Disability Rights California, but is formerly then was Protection and Advocacy Incorporated. And I worked there for 7 years prior to coming on over to Public Council. And my role at Public Council is really an intersection between disability and child welfare. So it's dual agency issues, and I guess you could say I'm sort of like the dual agency guy in California, where I focus on children who are jointly served by the regional center system and through the child welfare system, or juvenile justice, or out-of-home placements via a probate guardianship. So that's really my focus, 0 to 21, age 0 to 21. But don't hesitate to reach out to me anytime. So we'll get started. And first order of the business is making sure that our clicker is on.
Turned on. It's turned off. Hold on one second. There you go.
Troubleshoot that.
Okay, hold on.
Okay. So we'll move on to the next slide. That's working. Try it right. Well, okay, there we go. Maybe now. All right, terrific. What are regional centers? The first slide is very basic, and I'm sure all of you at some point have crossed paths to some extent with regional centers. Our focus at Public Council, obviously, with the Children's Rights Project, is that of the child who is a regional center child. There are instances, however, where our parenting and pregnant teen youth they're in the system as well, and they have children, and the parents are regional center clients. So similarly to you all, I think we have kind of at times similar populations. And regional centers are private nonprofit corporations that deliver the system of developmental services to those who are eligible to receive these services. There's 21 regional centers in the state. There's 7 of them in Los Angeles. The 21 regional centers exist because when the system was first created in the late 70s, there were 21 million people in the state of California. So they decided to have 21 regional centers to meet that capacity at that time. And here we are still, 40 years later, we're still at 21 regional centers, which sort of indicative of some of the problems of this burgeoning system that we have. I give presentations all the time, and I was just sort of struck when I was looking at one of my recent presentations from May. And in May, the population at that time was 328,000. So we've grown by 17,000 persons statewide in the past 5 months. That's sort of the rate of the influx coming into the system. And we're now at 345,000 as of October. The main roles of the regional center are to provide case management. It's targeted case management, which essentially the regional center is a conduit to link the eligible individual up to other agency services, generic agencies. You'll hear that all the time about the regional center. And those generic agencies could be the school system, it could be Social Security, it could be IHSS, in-home supportive services, any number of different Medi-Cal issues, all these different agencies, but the regional center is supposed to help facilitate that linkage. And they get funded in part with federal Medicaid dollars in order to execute that role. It's targeted case management. They are also supposed to provide advocacy assistance. So in our opinion, that means showing up to the meetings vis-a-vis these other agencies, whether it's an individualized education plan within a special education school district context, or it's going with the parent to Social Security Administration to make sure that they file an SSI application. Whatever the case may be, the regional center there's these expectations that the regional center perform advocacy assistance. And then lastly, of course, is the specialized services and supports, which are unique, specialized developmental services that have been vetted, I guess you can say, to be clinically effective and for which there is a cadre of service providers out in the communities ready to contract with the regional centers to deliver those types of services. And we'll get into some of the services in a little bit, but that essentially is the three-pronged roles of the regional center. Eligibility is not means-based, so there really aren't any restrictions on eligibility in terms of anybody can call in, and if they meet the underlying criteria, then they're eligible. And so maybe that's why we've expanded by 17,000 people in the last 5 months. It's just because it's a come one, come all system, so long as you meet the underlying criteria. And that also pertains to the immigration context, where you can be undocumented, and that's irrelevant in terms of your eligibility for regional center. What is required is that you have to be a California resident, which really can be proven by utility bills, your evidencing domicile. So there were some cases back in the 90s where the regional centers were trying to say that military people stationed temporarily in California were not residents and therefore were not eligible for regional center services at that time. I think they gave up on that argument for political reasons or otherwise. They backed off. So really anybody who is eligible can apply. And in Los Angeles, there are 7 regional centers. The largest one is North Los Angeles County Regional Center, which essentially serves everything north of the valley into Santa Clarita, into Lancaster, Palmdale, and beyond into Lake Los Angeles, which is 30 miles east of Lancaster. And that's geographically and by population the largest size. They serve about 26,000 people right now. And the smallest regional center in Los Angeles County is Westside Regional Center, with approximately 10,000 people that it serves. What programs are administered by the regional centers? Well, it's more simplified now. There was a time during the budget crunch in 2009 where every State Department really received significant cuts in services, and the developmental services system was, they were not immune to those cuts. And so the eligibility criteria and the programs that were offered were modified then. But it's just important to know if you're trying to get an application in and like, well, wait a minute, I think the criteria changed. It did, but then it was restored. It's been restored at this point. It has been so since 2015. There was a 6-year period where there was some confusion in different criteria. So we're back to where we were pre-2009. There are 3 programs. Kids under 3 are served under the Early Start program. Sometimes it's referred to as early intervention for infants and toddlers, 0 to 3 years old. And then at 3 years old, what should happen if you are already in the system and you were an Early Start participant is that you will have your case assessed for ongoing Lanterman Act eligibility to see if you're developmentally disabled and thus qualify for lifelong services through the regional center system. There's just this third ancillary program that is a historical program called preventative services that it really is a thing of the past now. But at one point it probably served over 1,000 people statewide, and obviously the population base during this time period was much lower. But it's designed to assist provide prenatal and perinatal care to expecting mothers for which there is a suspicion that the unborn child might be developmentally disabled, and that's genetic dispositions or otherwise. The thing with that program, though, is regional centers are always looking to see if there's another primary agency that has the foremost responsibility for providing whatever service. And in this context, we have Medi-Cal, we have private insurance, we have maternal health and child care programs now, that this last program has really diminished in size and in import now. So we're really talking about two main programs, under 3 and over 3. What laws apply to regional centers? With the under 3 legal rubric, we have federal law. IDEA is Individuals with Disabilities Education Act, and this is Part C of that. Part B is what we all know to be the special education system delivered through the school districts with an individualized education plan, an IEP. But this is part and parcel to that overall law, and this is Part C, where the regional centers are the lead educational agencies in this context to provide this service. There's also state law that has been enacted and regulations to basically deliver this system. And over 3, you have the Lanterman Act, which is an exclusively state law system. There's no federal law that really applies, only in an ancillary sense with the drawdown of federal Medicaid dollars, but really where the rights and the expectations come from is from the state program, which is governed by the Lanterman Act, and the regs are here as well. And there's some useful guidelines on these types of laws that are published by Disability Rights California that I would recommend anybody take a look at. They're very user-friendly, and they've been translated into 10 different languages, so it's all very good for families that you may be serving. So let's get into early start a little bit. This is going to be for kids who are under 3 years old and can be eligible as early as being days old and in the neointensive care unit at a hospital because maybe they've been on oxygen for the first two days of their life, or their APGAR scores were abnormally high. So there's biomedical factors that can come in that would warrant eligibility if severe enough. So you'll have that. As we know with this population, right, there's also the increased susceptibility of fetal alcohol and prenatal drug exposure. So these are all types of children that might be eligible for early start services. And indeed, we have the Child Abuse Prevention and Treatment Act, Capra, that requires DCFS to refer cases of where the child 0 to 36 months is involved in a substantiated case of child abuse or neglect. That DCFS then is the primary referral source under this law to refer these cases over, and they're obligated to do so. DCFS at one point in time said that they would refer a child under 3 years old to this program even if they were not the direct recipient of the abuse or neglect. If it was in the household with another child, the fact that there was a child under 3 in that household, to them that warrants them having that stone unturned. So this program. California has adopted this, and they draw down federal funds from the government to execute this program. And there are some children, however, who, although they qualify for early start services, their condition is such that they're going to be served by the school district, and that's going to be in 3 cases, and the cases are what's referred to as low incidence disabilities. That's children who have solely vision, solely hearing, or solely severe orthopedic conditions, or any combination thereof. If that's the case, and that is all their condition, then it would be the school district. Oftentimes, though, we see kids who have like cognitive impairments or neurological dysfunction in addition to these low incidence disabilities, in which case the regional centers and the school districts have memorandums of understanding to jointly serve these kids, where the school, for instance, will be providing the vision therapy or the audiological services to meet that distinct condition, whereas the regional center provides services in the other areas of concern. So that's the program. Now, who qualifies? Again, we're back to the standard that always existed before 2009. There was just a period of time from 2009 to 2015 where there was additional criteria, but we're back to what always was the case prior to. And so there's three categories. One is developmental delay. And this is actually the developmental delay and established risk are the two areas where for which the federal law mandates a state, if they're going to participate in receiving federal dollars and they're going to have a early start program, it's mandatory that each state who does so has a system for developmental delay and established risk. California has included a third optional category, which is high risk. So the area's developmental delay is 33% delay in one or more of 5 developmental areas for kids: cognitive, physical, motor, communication, social, emotional, and adaptive. So if a child is 18 months old and there's a suspicion that they might be delayed, they don't seem to be meeting milestones, expected milestones for that age, the regional center can do assessments for development. Bailey scales of infant development, for instance, is one tool that is used to determine the functionality of kids. And then to compare the child's actual age to what they're functioning, what age are they actually functioning like. So these tools bear this out. And so a kid who is exhibiting scores that are 12 months, they're functioning at a 12 months or lower, and yet they're 18 months, that's 33% delay, and that was what would grant eligibility under that category. But there are other kids who, they might be delayed, but not so significantly so. Let's say they are tested and they have general global delays across the board in all areas, 20–25% delay given their age. But they have what's called an established risk condition. They have Down syndrome, they have epilepsy, they have cerebral palsy, or they have one of those low incidence disabilities of vision or blindness. That automatically makes them eligible, notwithstanding the fact that they don't have what would otherwise be requisite delay under the first prong. And then really lastly quick was the children who are high risk, which is an optional category which we saw disappear for that 6-year period during the budget crunch, but which has been restored. And here you're looking at prematurity, prenatal exposure to drug or alcohol, parents with a developmental disability, which I know that really implicates a lot of your clients, that these are all bases for which to refer a case over for eligibility, because there's just a presupposition that the children will have, there needs to be monitoring and intensive early care and education services to stave off any sort of long-term developmental delay. I don't know if there was a question earlier or not, but maybe we'll move on. Okay, so early start application process. How do you get your foot through the front door? Well, you know, that could be self-referred. You can have the parent could make that referral. But again, like I said, some of these cases are referred by DCFS through the social workers pursuant to their obligations as a primary referral source under Capra and early intervention law. So the case goes over to the regional center. There's a form that is filled out by DCFS, which is the 5004 form, the 5004 form, that we actually, Public Counsel and the Alliance for Children's Rights and Disability Rights California, we all worked on having that revised. And I do believe Lauren was probably present at those meetings, Lauren Cottles with Lato. And we jointly developed this court form that DCFS would be using to refer cases over. But the inappropriate regional center, this gets sort of convoluted within Los Angeles County, and you see this up in the Bay Area as well, is that there are multiple regional centers clustered in an area and there's overlapping zip codes. But all I would say is there is a website on, which is the Department of Developmental Services website, where one could put in the zip code and that will pop up the relevant regional center. Or there might sometimes be 2 regional centers popped up under the one zip code, and then from there you call and you figure out, well, what side of the street is this kid living on, and that'll be whichever regional center will be the one to ultimately serve, whether it's Claremont or Montclair or something like that. You know, you have these areas sometimes. Consent is paramount, though. The regional center cannot move forward on an assessment for eligibility, or even if the kid is granted eligibility and they're ready and willing to start the service provisions, there needs to be a sign-off. There needs to be consent by the consent holder in order to do the evaluations, and then once the child's been made eligible, have services start flowing. So this is where we see sometimes a problem in getting consent signed. Parents obviously are by right, are the holders of this consent, or we sometimes see legal guardians pre-dependency involvement, where there might be, say a grandparent or an aunt or somebody who's the legal guardian for this child. But in the absence of that, and without the wherewithal perhaps of the parent, or the whereabouts are unknown, or they're incarcerated and their ability perhaps to make decisions is compromised, that's where the court and DCFS and even the minors attorney, CLC, might be pushing to get a rights holder, a surrogate rights holder in a sense. So in the early start context, that's the educational rights holder, because this is an educational program through the federal government, the IDEA. So educational rights. And that educational rights holder designee will also, it will carry over when the child becomes 3 years old, even if they continue with the regional center or not. They still could be involved with special education with the school district, and thus there'll still be a need for an educational rights holder. What we have been discussing in our quarterly meetings on these sorts of issues, for which Judge Philip Soto chairs these meetings, is the possibility of having co-holders, like joint holders of these rights, where you can have the biological parents still retain the educational rights or the developmental services decision rights for purposes of the Lanterman Act, but then handing that off over to somebody else. And so obviously I think that might work out better where you have a relative caregiver who still, maybe perhaps there's trust between the bio parent and this relative, that the two of them collectively can make decisions, or somebody can be on standby if need be. But that has been suggested and sort of less recognized and adopted by the bench officers as an alternative. So joint holders of educational and developmental services rights is definitely a possibility. We do have some cases in our system where the child's in a group home, and there just isn't anybody who can stand in the shoes for this child. In which case, group home administrators are not allowed under the law to be the rights holders. There's a conflict of interest with that. So that's where you might see a court-appointed special advocate volunteer, a CASA volunteer, stepping in to be the rights holder. Worst case scenario under the law, the judge can make decisions. The judge can serve as the holder of the rights to be able to make decisions under 361, as well as the 727 or 726-27 under the juvenile justice rubric. Ultimately, there is sort of a safety net in the law for that. But it is critical, because 45 days once the call is made or the fax of the form comes over with the referral, this DCFS 5004, that's where that imposes timelines on the regional center to act. And under the federal law, they have 45 days from the date of initial contact to assess this child, to determine eligibility, and to hold a meeting to do some program planning. And so it's a very quick process, but the law kind of acknowledges that sometimes consent is not there. So the clock starts, but then it's suspended if you can't get the consent. And then only when you get the consent really is where that clock starts again. Yes, Rachel?
So a lot of times we have the court ordered the regional center referral for one of our client's children. And if our client has custody of that child, then the burden is upon them to request this referral. But could in that circumstance, DCFS still just use that form and fax over the referral themselves?
Absolutely, they can. I think maybe there might be some deference with you representing the biological parent that maybe, you know, maybe one step towards let's get the child referred and see how, if the bio parent follows through on this referral. But DCFS does have its own jurisdiction to refer these cases over, particularly for the kids under 3 where there's these Capra requirements. And even the federal IDEA law would say that irrespective of what the bio parent's doing, there has to be a referral. But again, once that referral is made over, the regional center says, okay, we're going to open up a case, but we can't start the assessment process until we get consent. So if they can't get consent from the bio parent, then that triggers, that could be a hearing to order somebody else to stand in the shoes and be the rights holder. So that's where that could get implicated. But I think this initial thing like, well, why don't you do it, bio parent? That might be because they're trying to see if the biological parent is going to follow through on that.
And then what sort of forms does the parent have to fill out in order to request the assessment? I mean, is it easy? Is it hard?
It depends. Those are great questions, right? It depends. There are 21 different regional centers. There are 7 regional centers in Los Angeles, and they all have different application forms. And looking at North Los Angeles, for instance, I know that just reading that and seeing that, it's pretty daunting. You know, it can be daunting to fill out one of those forms, at least from some regional centers. So I know that can also serve as a barrier sometimes. Should the DCFS social worker help that parent to fill those forms out, right? You know, maybe one might think that that's a role that DCFS can do if it's so much of a barrier for the parent to fill out that form. But it does vary. The regional center as well, one would think that they also should be helping to facilitate getting those applications filled out. But I understand that that could be a barrier sometimes.
That was actually
Yeah, it varies. There's no standard. The whole nature of the regional center system is that it's locally driven. There's a hands-off approach with respect to government oversight. The Department of Developmental Services, and there was actually a 1985 decision, the California Supreme Court decision, that says the department really should have little involvement in the day-to-day operations of the regional center. They can oversee fiscal management, that the regional centers are not overspending. They can make sure there's no conflict of interest in some sort of like nepotism deals. And another area I'm looking at where I really think DDS, the department, has really fallen by the wayside is to make sure that regional centers provide services in a culturally and linguistically competent manner. We're really seeing problems with that. But beyond that, each regional center kind of gets to decide how they want to operate. And so it's localized, it's driven by board of directors and the staff, and it just depends what regional center you're dealing with. Yes.
Can we make referrals to public counsel or the Alliance to help our clients?
Yes. So the question is, can you make referrals to public counsel or the Alliance for assistance with these clients? In my case, absolutely, except for eligibility. That's something that I have. Eligibility is sort of its own realm. And it really requires ongoing expertise in order to challenge regional center denials. And so the agencies that do that kind of assistance would be Disability Rights California and their Office of Client Rights Advocacy offices, which I have that information on the back of this handout. So if eligibility is at issue, that's not something that myself takes on. I know with the Alliance for Children's Rights, they have had some eligibility work in the past, particularly when Sasha Stern was operating the Alliance's program. But they've gone through a lot of staff changes as well. So my recommendation is if it is eligibility, you need assistance, contact Disability Rights California or their Office of Client Rights Advocacy. Now, if they're in the system already and they're not getting properly served, which we know that happens all the time too, or if there's a caregiver situation and it's financially unstable because DCFS hasn't been providing the proper rate for that family, that's something else that I could get involved in. So I can assist on cases for which eligibility has already been established.
Just
Yes.
to follow up on that, does the Disability Rights California or the Office of Clients' Rights Advocacy, would they assist with eligibility for adults or only?
Yes,
Okay.
absolutely, for everybody. Yeah, they're basically the go-to organization for eligibility. And they've earmarked funds for that in their budget, and they have contracted experts that they work with regularly who have the familiarity with the eligibility laws to the extent, and monitoring the trends too, looking at the hearings on the public database to see, you know, who are the judges, what are the issues, and they're really the ones that to monitor that, and they have that the resource capacity to do so. So definitely, those are great questions. Regional centers should be assessing the kids comprehensively, and then if you're made eligible, then you have this program plan, which is the IFSP, the Individualized Family Service Plan. It is a contract, so once the regional center agrees to provide services under that contract, whatever's dictated by the developmental assessments, then they should be held to that. And yet we see cases all the time where providers don't show up, or the kid gets moved from one placement to another, and there's not a seamless transfer of that case, and so months go by and the kid doesn't get served. Compensatory services should be available to that child, and that again is something where public counsel or the alliance could come in to work on that to make that child whole for any gap in services. We would hold the regional center accountable to the contract that they entered into with the family. And this is done every 6 months to monitor closely the progress or lack thereof. But one can ask for a plan meeting anytime. And now with the change in the law, we now have the regional centers required to conduct this meeting and to provide the ultimate memorialization document of the meeting, the IFSP document, in the family's native language upon request. Again, this is something that families don't know to request. It's held in English, even though they speak whatever, Spanish or whatever, and they don't quite get everything, but nobody knows to ask, and so things get missed. But the family has a right to request it, everything be conducted in their native language, and the regional center should be honoring that, but again, it's a problem. These are really the requisite elements of this family statement, and in your context, obviously, there would be this issue of DCFS oversight if there's an open case. They will assess each child in those areas to figure out, well, where are they, like I said earlier, what are they functioning, what level are they functioning at, where should they be, and what types of services and what frequency and duration of services should we be providing to try to narrow the gaps that we're seeing in this. And so you have all that information, including the end would be the transition information. That by transition, the regional center is obligated under federal law to make sure that that kid gets assessed by the school district for possible special education services prior to closing the case out, as well as evaluating that child for ongoing regional center eligibility under the Lanterman Act, which is different, more restrictive criteria. But that is something that the regional center should be doing as well. And again, this is where we can get involved. The kid's already eligible, but the school says, well, we're on summer break. We're not having any more IEP meetings. Call us in September. It's like, well, the kid's going to be 3 years and 2 months by then. You know, what's going to happen for the 2 months? Who's going to serve them? And sometimes the regional centers are asleep at the switch here, and they don't start this process early enough. And this is where we can get involved. Here's the exclusive list of services that are available under the Early Start program, because this is all generated through federal dollars. And for every service here, there's federal matching funds, with the exception of durable medical equipment. That's the one service that California pays for with state funds to help meet the need. But a lot of what's happened, especially with kids who are medically fragile, the parent has a child who has complications, and the child might have a feeding tube, or they might have oxygen dependency. And this is not your typical 2-year-old, right? And yet we see the regional centers oftentimes overlooking the need to help support these families. And so the families go without. They're entitled to nursing services, which is not really respite, but sometimes it's confused as respite. Respite itself is one of the services that the regional centers are no longer mandated to provide as of 2009. So if the family is just needing to get a break from the constant demands of the child's care, to get away, watch a movie, go to church, whatever the case may be, it's not available for kids under 3 under early start. That's unfortunately not something that we'll be able to rely upon. That's where perhaps you might want to ask for DCFS to see if DCFS can provide the respite services to help with whatever stabilizing this family home. That's something then as an alternative. So then we get into the Lanterman Act. We have people over 3 years old. The regional center should be assessing at age 3, but we have plenty of people who apply after age 3. And in fact, I had a friend of mine whose brother was 35 years old when he first applied to the regional center system. And providing that you can establish eligibility, that the disability originated prior to age 18, the regional center should be working with that application and assessing. So this is the system in California that provides developmental services. It's really regarded among the nation as being the one that is of the utmost entitlement. There are other developmental services systems in other states that have population caps or income limits, all these different things, but in California we don't have any of that. And so it really is a way to self-empower the person with the developmental disability and really shift away paradigmatically from this old medical model where we used to institutionalize people, and instead integrate them into society, community integration, and apply a more social model to them, that they're part of our communities. And how do we go about effectuating that? Well, we have this home and community-based system that provides these specialized services. So what is a developmental disability? Here, I got this all on one slide, but there are 5 categories, one of which is related to the first. The 5th one is the 5th category, and it's really part and parcel to the first. Intellectual disability is the predominant developmental disability in California still, and Down syndrome is the leading etiology that gives rise to intellectual disability. So you can be born with it, it could be congenital, or it could be acquired. And unfortunately, as we all know, it could be acquired. We've seen cases, I've had shaken baby syndromes, or the prenatal exposure to drugs or alcohol, obviously. Well, that's being born with that, obviously, but acquired cases. I've had some legitimate accidents happen, too. Seen that with respect, especially with the prior work that I did with Disability Rights California, where one case, the mother got the child a hot dog at the fair and looked away for several seconds and turned back around and realized the child was choking on that hot dog, and she asphyxiated. And then that rendered her in a position where she's lifelong care now. So it could be acquired. So long as it's acquired before age 18, that's the criteria. That's intellectual disability. Autism spectrum disorder is what we have now, which is a reformation of the the clinical definition, I suppose you can say. The DSM-5 was revised in 2013, and it redefined autism. It actually redefined intellectual disability too. It emphasizes less so IQ testing for intellectual disability and focuses more so instead on adaptive functioning, on how well you're able to navigate society. But with autism, we saw a huge change where before they had delineations of what did you have autistic disorder, or did you have Asperger's syndrome, or did you have some sort of other condition, some pervasive developmental disability not otherwise specified. That actually was a category. That was all DSM-4 and prior standards. With DSM-5 now, it's simply autism spectrum disorder, and the question then is just how severely disabled are you by it. So again, we're seeing the population rise, and it's primarily autism that is on the rise that's accounting for our increased population. It's the second leading disorder, and by far and away it's exponentially increasing at a rate much higher than the other disabilities. Then we have cerebral palsy and epilepsy is the other two main ones. Yes?
Just two quick questions. One, and this is an eligibility question, but when it comes to autism, there are people who are diagnosed with autism. Regional Center doesn't diagnose them,
Yes.
that are not Regional Center
Yes.
eligible, right? Okay.
That's correct.
So that's number one. But the Regional Center determines how disabled they are, and that's the criteria?
Well, those are really good questions. So the one is, there's a group of kids who have autism, but they don't qualify for regional center. And then who decides who has autism? So the first one indeed is correct, that you can have kids that receive special education services through the school district for having met federal law, which is simply an autistic-like, having autistic-like characteristics, and that's the standard there. You can have that same person eventually apply for SSI, and so Social Security Administration has its own standard of, they still use pervasive developmental disorder, which is the pre-2013 criteria. So other agencies might be applying different standards, and indeed the person is recognized as a person with autism. But to be eligible for regional center services and be considered developmentally disabled in order to access regional center services, the sole arbiter for that is the regional centers. And so there are two main categories with autism. One is social communication deficits, and the other one is this restricted and repetitive behaviors. And those are like the two main global areas. And how that's ranked is there's 1, 2, and 3, with the third ranking of 3 being the most severe. And so we've had regional centers say, well, we've evaluated you, and yes, you have autistic disorder. We're seeing both of the traits being present, but they're just at the lowest level of severity. So we're not going to serve you. We understand you have autism, but you need to go to the school district to get served, and not through us. So it is possible that you'll see that. Really good question.
And
So
just one more thing, because our clients, most of them are over the age of 18, right? And so
Yes.
it's hard to establish before 18?
It depends. I mean, is there documentation that relates back then? The question again for others in the satellite is, we have a lot of clients that could be 18, who are 18 or older, and what do you do and how do you try to get through the front door? Obviously, if there is pre-existing documentation, that would be extremely helpful. The case of my friend's brother, who was 35 when he applied, they fled Vietnam, but there was discussions about his history, what was his history, and that he was in special schools in Vietnam. When they did the testing, and you can request, for instance, neuropsychological testing that will actually look at the organicity of the brain, and that could help to approximate whether this condition had always existed or not. It's possible to use
So when we know that it occurred, disability occurred after 18, like say traumatic brain injury,
Yes.
accident, so who, if not regional center,
Yes.
would help our clients?
Right, great question. So another question came up, what happens when the kid's in the car, he's 18 years old, he's drag racing, he's past age 18, but gosh, something horrible, he gets in an accident, he hits a pole, and he gets a traumatic brain injury, and he's completely, had that happened before age 18, absolutely, no dispute, he would be eligible for regional center, but it happened afterwards. So where does he go? He's in probably some sort of skilled facility, nursing facility, paid through Medi-Cal funds, Medicaid funds. Probably that's what you're going to see. Or if it's one of these cases, maybe not be that severe, but obviously have the traumatic brain injury. There's still Social Security, there might be private insurance under, the parents or something like that. There might be some other system out there. School districts are still obligated to provide services to people who qualify up to the age 22. And you don't have to have regional center eligibility to access that. So there's a number of other agencies out there, but obviously having the regional center of sport would be critical, but the 18-year-old that's the problem. Yes?
How helpful is it to get a hold of our clients IEPs, special education to help them
Yes.
qualify, because I just had, last week, I had the, yesterday? Yeah, I had the court order the department to get a hold of the parents' records, because she couldn't even explain what her disability
Yes.
was, for the
Yes.
reason being in special education, so.
The more documentation, the better. And that was the question, is how helpful would it be to get the client's IEPs? And I'm presuming now this is a parent, you're trying to establish eligibility past age 18. Absolutely. It can be a double-edged sword sometimes, in that the regional center, as we have down here, will exclude conditions that are solely learning, psychiatric, or physical in nature. So if you have the IEP and they say, yeah, this person qualifies for special ed, but on the basis of a psychiatric disorder, the regional center says, well, that's not us. We provide developmental services to people with developmental disabilities, and this is a psychiatric disability. Nevertheless, I think that information might be helpful for your purposes, and trying to link it up to whatever system is responsible to serve that person. But for regional center eligibility, sometimes there are references in documentation that could be problematic, and that's just something that we have to deal with. And there are other cases where you just don't have anything, but then you say, well, let's ask, has this person ever worked? If so, how long did that job last? Who were the prior employers? What were the deficiencies there? How about growing up? What was this child's like in the neighborhood? Are there ways to anecdotally try to build a case in the absence of documentation? So sometimes you're just left with that. Really good questions, though. These conditions have to be expected to last age 18, and you have to be disabled in at least 3 or more of these 7 areas that are listed here. The last 2 areas, we have capacity for independent living and economic self-sufficiency, which really are not that relevant to younger kids, right? So they're left having to establish still 3 criteria with effectively 5 applicable criteria to them. So it is really counterintuitive that you have to make them, could be making a more difficult case with a narrow scope of criteria for the younger you are. And then again, once you have that diagnosis and it translates into that functionality, you're substantially disabled in at least 3 of the 7 major life criteria. Getting into the regional center is similarly so, just like the early start process. You need to have consent. Now, we have what's called a developmental services decision maker, which is the equivalent to the educational rights holder, but only it applies in the Lanterman Act context for applicants over 3 and for anybody who's going to be served by the regional center system. So I actually, this was my law that I had passed through Carol Liu's office under SB 368, and this originated because we had maternal grandparents out at Inland Regional Center who were serving a child who had shaken baby syndrome and was served under the early start program, but did transfer over onto Lanterman Act. And we were finalizing the adoption for these maternal grandparents, but ultimately as well trying to stabilize that home with appropriate services, including a child who had medically fragile issues and warranted more services from the regional center. So we interfaced with them, and Inland said, and there was never an issue with Inland before our involvement of allowing these maternal grandparents to sign off on things. Don't ask, don't tell, sure, I'll just sign here, you're basically the physical caregiver at this point, we'll recognize you, and so that was the case. But when we went to file for a fair hearing against the regional center, because again, it was our opinion they were underserving this family, they said, well, wait a minute, this family doesn't have the right to challenge us until they can go and get a guardianship, or they can have their adoption finalized, but before that, they don't have standing to challenge our decisions. And the scary thing at that time was they were right. There was nothing in the law that granted these maternal grandparents the right to to act on behalf of this kid. We got a individualized court order that extended this right to interface with the regional center in that context. But we came up with a law to really extend this, because these kids are, until age 21 in terms of foster care, you have non-minor dependents still who can have a developmental services decision maker making decisions for them. And in the context of special education, they're entitled to a special education program until age 22. So you need to have these surrogates still making decisions. And so we came up with that, and that's pretty much now made its way not only within the regional center system, but statewide and judicial council. There's the JV 535 form that has a box that's to be checked for developmental services decision maker. And that just means that this person is the educational rights holder, and also, because the child's eligible for regional center, developmental services decision maker. So that's all there, and that's been memorialized. And again, sometimes when we have issues with consent and there are like ex parte hearings or whatever, to try to in an emergency fashion, trying to get somebody appointed to make, it could be in a case, health and welfare of the child is at issue, that we have folks getting the requisite custodial rights to this developmental services decision maker, and the JV 535 form signed off by the judge. If you have that, or if you get that and you make the application, unlike Early Start, where there's a strict 45-day timeline mandated on federal law, what we have here is state law under the Lanham Act, which gives the regional centers 15 days to even consider making opening a case for establishing eligibility. And this is what's referred to as initial intake. And so we get calls sometimes, we hear of anecdotes that people will call and say, well, did you try to contact the regional center for setting up an appointment? It's like, well, yeah, when they ask, well, what conditions they have, and it's like, well, it says here on the school he's got behavioral issues, and they're like, right, was it psychiatrically based? Well, what does it say? It really can lead people down a path. Regional centers have been known to deny cases and not getting past that initial 15-day intake because people are not saying the right things, and the case is not making their way through. So that is problematic. But if you're able to get over that hump, then it opens up this 120-day process. Yes, Ruth?
We only have about 5 minutes left.
Okay,
Would you mind
goodness.
discussing some
Let's
of
move on.
the services
Absolutely.
for parents?
Yes, let's move forward. Once you're in the system, you're in for the most part, and there's another provision about transferring over from one regional center to another. That's another law we got, so that's something. You get your IPP. Again, this is just like program planning, just like what I explained earlier. It's a contract. They have to talk to you in your native language. And then there's these services that flow from that, and here's the process to determine that. It's really needs, effectiveness, and cost effectiveness of the service that dictates whether or not you're able to get the service from the regional center. But what are the types of services? This is your question, Rachel. And we have those for kids, and this is a non-exclusive list for kids, but then we have adults too, and this is who you're serving. So there's there's other ones here for kids who are 18 to 22 years old. There's some restrictions on that. Let's get to this. Services for parents with developmental disabilities. And I mean, services go into life, right? So this is within the context of a dependency proceeding, pretty much. Because you'll have work programs, or you have day programs and all those, and residential placements for adults. That's all out there. But specific to court involvement, the regional center by law, which is 4687 of Welfare and Institutions Code, they're mandated to provide these specialized services for court-involved adults. So you have parenting courses, you have anger management courses, you have sexuality training, family counseling. Advocacy assistance is going to court. The regional center service coordinator should be showing up to court proceedings. And then coordinating with other agencies and helping people access the other agencies' benefits. So that is more or less a quick overview of the types of services that might be available to adults who have a dependency case opened up against them. That the regional centers can come in and provide services to help.
Years
Yeah.
ago, there used to be a placement where mothers, developmentally delayed mothers, regional center clients, and their kids could live together. Is there anything like that out
Yes.
there anymore?
Yeah, that's a great question. The question is there some sort of residential placement for regional center consumers where they can live with their children? And presuming in a dependency context, that is an open court case?
Or
otherwise,
Yeah.
yeah. To my knowledge, right now, no. And the reason being on that is there is this move to try to deinstitutionalize the group home model. And they've actually, for any group homes now, they're really paring that down to 4 beds or less, whereas in the past you would see upwards of 6 to 18. So they're really trying to shift away from that model. On the other hand, regional centers have gotten more flexibility in the last couple of years to do resource development. Everything's localized, right? So there's no one sort of thing that is going to be applied across the board to all 21 regional centers. Regional centers have flexibility to assess their own local needs and then request funding from the department to get services and resource development that meets their needs. I think you probably see like Lancaster, Palmdale, North LA probably could stand to use for our clients, especially our short-haul clients, more homes, like you said. There should be homes where parents can learn the skills. They can learn not only this, but work, vocational skills, and how to be a better parent, and do so within a developmentally appropriate setting with 3-4 other mothers similarly situated. We don't have that right now that I'm aware of in LA County or even the statewide, but it's theoretically it's possible. And so that would be something that we would want to be asking the regional centers, what are you doing with the flexibility of the funds that you're able to utilize for your resource development? And have you considered that, or will your regional center consider constructing such a group home for that purpose? It's a really good question, yeah.
But they do have, like, in apartment complexes, say there's 20 units, they'll have like 5 units for regional center clients with an on-site person to manage their cases.
Yes.
Would that be adapted for our clients?
Right. The question is, there are sort of apartment complexes, and there there are consumers living there, and there's on-site people. That's true. Could it be adapted? I think we have to let the regional centers know that there's a need for that, and that they should be, what do we do with the other people there who are single people? So I think there'd have to be some reshifting of that. Could those people be converted over to an independent living situation, or their needs more severe, they need more of a supported living, more a hands-on thing, but then bring in these folks, right? Bring in the parents that are with their children, and the parents themselves are developmentally disabled. I think it's a great proposal that should be, this is something that Rachel and I talked about earlier, actually. It's like getting Ladle have, being at least these quarterly meetings and advancing these sort of policy proposals. The regional centers are there, and they've asked us, well, what ideas do you have for us that we can take to the state? What are you seeing? And in our context, it has always been children who need to be in a group home that don't have any family person. So group homes and the availability of group homes for kids under 18 is almost non-existent now. And that's very unfortunate. So we've seen, particularly for severely behaviorally challenged kids with high level autism. So the department, the DCFS, is like, at one point they said we have 12 kids that are locked up in college hospitals, which is in Cerritos. And it's a 24-hour institutionalized system because their regional centers don't have group homes for these 16, 15, 14-year-old kids. So we raised this issue of resource development in the context of that need, but certainly the need that you're raised to is also really relevant.
It used to exist when
It
I
used to
started doing
exist.
this 20 years ago, and it was the only cases pretty much where we got reunification with regional center parents
were those cases.
It happened, and reunification was successful because of such placements, absolutely, yeah. I think 20 years ago, we had McLaren, and there was some funds that were brought out to address the deinstitutionalization of McLaren, and I think over time, you know, people forget, the eyes are off the ball, and arguably, you know, other priorities come up that some people think are more warranted, and so these kinds of things fall by the wayside. But yet, now that there is this flexibility of how funds can be spent by the regional centers, it should be raised again. So
We're at time. Do you have a few minutes to stick around? and
I
follow up questions?
absolutely do have time, and I don't think there's really anything other than just to know that the regional centers have purchase of service guidelines on their website. You can see the types of services that I list here. If you want the specific policies from the regional center, you're entitled to access those. And they should be online, but you can ask for them independently. And we've discussed a lot of this issue. The other main thing that's going on right now is behavioral health treatment. And private insurance and Medi-Cal, for the most part, are the primary payers for that now. But if the person under 21 is still linked up to the dependency system, they have what's called fee-for-service Medi-Cal or straight Medi-Cal. So that's where the regional centers still have a role to play. And those are the main things. We have other supports that you might think about. We talked about this. What if the kid's 18 when they get hit and they're not eligible for regional center? You have SSI, you have survivor's benefits, you have in-home supported services, special education services up to age 22, California Children's Services till age 21. Department of Rehabilitation provides vocational development for people with disabilities. And then there's mental health services that are also out there, particularly if you have a case where the person is primarily psychiatric in their diagnoses. And so there are these other agencies out there too. And I think that's it. You can file an appeal against the regional center. If you get a notice of action, they're trying to cut a service, you want to appeal within 10 days to have that service continue. And that's really the nutshell of my presentation. I have my contact information. There's the Office of Client Rights Advocacy, and the Alliance's number is here as well. So I know it's never enough time to talk about regional centers, but you had great questions, and thank you all. If you have any questions, I'm happy to talk about it. Thank you, thank you. Thank you, okay.